So welcome everyone here today. It is 2:01 Eastern, so we're just going to get started. I just want to welcome everyone. I'm Sean Kosofsky, the Nonprofit Fixer. We messaged a whole bunch of people about today, and we had about 70 folks register that they were interested in coming live or getting their questions answered. I do see some people here that I know, which is really great. Introduce yourself in the chat, give your name, your organization, and your city. In just a second, I'm going to introduce our presenter today, who's going to answer tons of your questions. If you have questions, you can put them in the chat. I will then put them in the queue for Allie to answer. So if you have questions for today, don't just jump in with them. We would prefer to have them in writing. So be thoughtful and put them in the chat. So I'm going to hand it off to Allie here to introduce herself, and then you will still see me on camera during the training today, mostly just to be reassuring for folks from my list and community who want to know what they've that I'm here as part of this. And I might every now and then pipe in with like a clarifying thing as a non-attorney. But Allie, why don't you introduce yourself, and then we will dive into the questions that we have that were sent in advance, unless people have them in the chat. Go for it.
Thanks so much. I am Allie Levene. I am the founder and attorney at Levene Legal, which is a law firm I founded. We focus on affordable and accessible legal services for small businesses and nonprofits. And my passion from nonprofits has really come just growing up, very service-oriented family, doing amazing work. And in my practice, I was finding that nonprofits were running into a lot of issues and they weren't getting the proper proactive legal advice. And so that's what I do in my work. And I hope to provide some insight today. I will just say, the little disclosure I have to always say, this is not legal advice. This is for educational and informational purposes only. But I'm really excited to be here. And like Sean said, I'll start with the questions that people submitted, but please feel free to add in questions or even follow-up questions to something I say, because hopefully something I say, somebody else's question will probably spark something that relates to you. So please feel free to follow up. Um, so I think one that I'm going to start with is something that I see common. And the question asked was, what are the top HR compliance risks you see for organizations with fewer than 10 employees? So the first one, and this really applies no matter what number. It is much more common in smaller organizations, especially organizations without an HR function, is the lack of things in writing. Um, when things go wrong, right, and when it comes to a lawyer, the first thing we usually say is he said, she said. The employee says this happened, the employer says this. And unfortunately, when it comes to legal stuff, if it's not in writing, then there's not much we can do about that. And so a lot of times that comes with things like when you're doing disciplinary action or you're writing up an employee or an employee is requesting an accommodation. It's so important to make sure you have a trail in writing, whether it be emails and in their folders. So that's the number one. The second one, especially at smaller organizations, is when there's a lack of a clear chain of command. Um, that can create a lot of risks and issues because things are getting missed. But most important, employees need to know where they can go, especially when it is an HR related matter. So if you don't have an HR person who is going, if I have a request for a reasonable accommodation, or I have questions about PTO, right? Who do I go to? And it's really important to make sure that's clear. And so that's spelling it out in places like your employee handbook. Or communications. And the third one is just because you're small doesn't mean you don't need HR. It may not look like an in-house person, but if you're going to have employees, you are taking on a lot of risk. When you add an employee, you're having all of these new legal requirements that you have to meet, and especially depending on the state you're in. So I live in Connecticut. Sean's in New York. Those are two examples of states, if you're in those, where we have really stringent employment requirements. So when you add an employee, you're adding on all these obligations. So even if it's just meeting and having a consultant that can guide you, helping you find the right HR platform, it's an important investment that I found with organizations that I work with, and it's a really important investment to make while you're small so that you can grow and you're not growing with these HR issues along the way.
Can I jump in with a real quick thing?
Yeah.
I've read from some attorneys that the single biggest mistake they see nonprofits make is misqualifying or classifying an employee as an independent contractor. Can you address the risks of that and how nonprofit, that's like a non-nonprofit issue, it's like an all company issue. Address how people can deal with that, and then secondarily, can the required whistleblower policy that all nonprofits are supposed to have in this country include a provision of how people can go to the board when they have a complaint? Are those two ways to tackle those things you mentioned?
Yes. Um, so I'll quickly tackle the whistleblower thing because that's quick. The independent contractor is a little more in depth, but absolutely, with your whistleblower policy, it's not enough to just have one, right? It needs to have clear reporting procedures. And so that would mean where to go. And if that means for different things, they need to go somewhere, but especially at a nonprofit, right? Spelling out when can you bypass, say, the executive director and go to the board? When is that okay? So I think that's really important to include. And you are absolutely on the money that one of the biggest risks for any organization, whether they're a nonprofit, small business, is independent contractors. And that's because if I classify someone as an independent contractor versus an employee, I'm saving a lot of money. I'm not paying payroll taxes, not, no workers' comp, you don't offer them benefits. The biggest risk comes, right, if they really are an employee. So how do you tell? And the difficulty is there is no one test. There's no easy rule. And that's because they can be an employee for purposes of taxes, but for purposes of workers' comp, they might not be. And what I mean by that is every different law has different definitions of an employee. So if you are hiring, whether it be an employee or an independent contractor, it's really important to run that by a lawyer so that they can look through the necessary tests because it's going to depend on specifically what you're doing, what other employees you have, the specific stuff that they are going to be tasked with. But the key, I'll tell you, when you're doing an independent contractor relationship is the contractor has to control how they work and when they work. That is one of the biggest pieces. If you are controlling how they're working, what they're doing, when they're working, you're giving them the tools to do it, they're more likely an employee. So I'm going to go to another one that I saw was really common. We got a few on this, and the specific question, but they're also related, was whether, well, I'm just trying to find it in the list, but it was whether a nonprofit that has all volunteers can own property. And so we did get a few questions about real estate. And so I wanted to bring this up is that when we talk about what nonprofits can and can't do with real estate, it's really dependent on what state you're in. And the reason being is state law kind of controls our real estate, right? Your city and your things like that. But what I'll say is, on its face, you're not limited. It doesn't matter that it's all volunteers. If you have the money, you can get the loan or whatever the circumstances are. There's nothing on its face now, right? But again, depending on where your organization is, if there's any specific rules, um, there's nothing barring you just because you don't have paid employees. You're not prohibited from owning real estate. I'm just going to go ahead and
Yeah, go for it.
with the next one. Hold on. Okay. So this next one, someone said, my employer wants to give me a bonus for every grant I'm awarded um, as I apply for more grants. Is that allowed or ethical? So I really like this question for a few things because I think nonprofit compensation, including executive director compensation and other key employees, doesn't always get talked about enough because if you're in the private sector, whatever somebody wants to pay you is fine. But nonprofits, it's not just about if the nonprofit has money. The IRS wants to make sure what you're being paid is reasonable and it's not excessive. And so the structure itself is not a problem, right? As long as they have the money and imagine it's not coming from those grants specifically that you're getting and that it's coming from funding sources that you can use the funds for this, as long as your total compensation is not unreasonable, then it's fine. How do we figure out what's unreasonable, right? And this goes for any structure, whether somebody's, getting a retirement package, any sort of benefits, or just their straight salary, is the board who's making the decision is required to look at comps. They're required to look at similarly situated organizations and see, is this similar? They also need to look through the job description and make sure what they're paying actually meets those things. It's not just assign a number. The other important thing that gets lost a lot is sometimes the employee may suggest a number and a board that's not enough, right? The board has to be the one coming up with the number, making sure it's reasonable. So with that, you can be awarded a bonus based on grants as long as your total compensation itself is reasonable and not excessive. Because when we get into excessive compensation, you know, nonprofits, they are tax exempt mostly. When you start doing certain things, you may get taxes. One of those is if you pay employees too much. But I will say we don't see it very often, right? And it's not a common thing, but it's something you need to be aware of. And it's one of those things that it gets looked into. Let's say if there's something else that raises concerns, right? Then they might look at and looking at your 990 and saying, that number seems strange. So it's you want to have all your compliance in a row so that way if something else goes wrong, you're not worried about this issue being found out.
And just to answer the underlying question I think this person is asking is in the fundraising world, it is common for fundraisers to hear that it is unethical to be paid more based on how much you raise. So because grant writers and fundraisers have been told, and there are some allegedly, I haven't read this in years, but I'm not sure if the different fundraising associations that exist. Association for Fundraising Professionals, AFP, might be one of them, but other fundraising associations around the country might have a ethic that says if you're paid more based on what you raised, that is unethical. So that creates a conflict for the employer who might be fine with it, and the employee who certainly is fine with it, but the donor might be like not, they don't want to see the bigger gift they give, the more salary goes to an employee. And I think that in general, paying people more based on how much they raise is frowned upon. I definitely think that when you are getting grant, that's a performance-based
Right.
raise. You can get a bonus or a raise based on a number of things you got. It has less to do with individual donors and the number of grants you receive. I think that is more okay than getting more money based on individual donations. And just as a professional fundraiser, um, the exception to all of this is campaigns. So a capital campaign or a political campaign, the stakes are high. There's a deadline. So sometimes organizations will pay people performance-based bonuses and salary increases based on performance of how many dollars were raised, but it's at the end of the campaign, not based on individual gifts that you're getting throughout the year. So am I right on that? Can you want to attest?
100%. And I think what you're touching on is the difference between legal and ethical. Legal and ethical are not at all the same. Many things are legal, but that doesn't make them ethical, right? And so a lot of this too is when you ask, so it is legal, right? When we come down to ethics, that first requires us to kind of look at like yourself. And so even if, right, let's say the board is offering that bonus, right, with your own ethics, does that make sense? But also looking at what other ethics of any organizations you belong to. And so ethically is more right like that cultural and yep, right, just as you said it, right, morals and those things. But it's whereas the legal, it's I can and I can't do that. Ethical, right? So I think that's one of those things. But I will say I have personally similar. I have seen it where they were getting it based off of like a larger amount. It wasn't, hey, each time a donor comes in, this particular one, the more events they booked, it wasn't grants, but it was event based. That person got similar structure, and I think that also goes into how the ethical, right? How it's structured, but also whatever money is being used to pay that bonus, right? Are donors aware of that? And all of that goes into the ethics and making sure you're advising them if their money is being used for that.
So the person who asked the question, yes, it is perfectly legal and ethical for your employer to give you more money based on the more grants you have submitted and the more grants you get. I think that's perfectly fine.
Yep.
You may want to check with your professional fundraising association if you're a member on whether or not this is and figure out whether or not that's something you're okay with, but it's perfectly legal for the purposes of a legal webinar today.
Yes. Perfectly said. All right. So I want to move on to one about volunteers. Talked about executive directors. We got some questions about volunteers. And one really good one we got was, when is a waiver needed for volunteers? So the first thing to think about this is obviously it's going to be different for every organization, is what actually is a waiver? A waiver is when the volunteer is saying, I'm waiving my legal right to basically come after, to sue the organization if something goes wrong. So how you decide if you need a waiver for volunteers is you look at what are the volunteers doing? Could something go wrong? And could they sue the organization? And if the answer is yes, even remotely, then you should be having them sign a waiver, right? Even if it's they are tabling out at a farmer's market, right? They could trip, they could get injured. And every state has different rules about volunteer liability and when organizations are responsible. It's also really important to make sure that your volunteers are covered under your insurance policy if you do rely on volunteers. So that way, if something does go wrong and they do bring a suit, let's say they get physically injured, um, you are covered and it's not coming out of the organization's pockets. So the first thing I would do is looking at what risks are there when you have volunteers involved in your organization and saying, is there a risk that something could go wrong and we need to protect ourselves? And if the answer is yes, then that's what you need a waiver for.
And another way to think about this, as a nonprofit, you're operating in the world, and every time you engage with someone, you create risk. When someone comes onto your website, they could give away their data or get a virus. If someone comes to your organization, they could slip and fall or be accused of something, right? So anytime someone interacts with your organization, you want to have them sign something. It isn't like everything all the time, but you want the higher the risk, the more you want to have them sign something indemnifying you so that you are not held liable. So your board members, you might want to have something for board members, you might want to have something for volunteers, anyone who's accessing your database, anyone who's on your property. And is there something like a blanket indemnification policy? Could you have everyone who comes into the organization sign a thing saying we're allowed to use your photographs when you're at our events, and you're allowed to we're blanket identified, or do they have to go topic by topic?
No, I see. You certainly can. It comes down to the ethical question, right? Like, do you feel comfortable that every person, because especially if you're an organization that maybe serves vulnerable populations, right? So it really depends who is everyone. But I reckon, so all that to say you can, but I think it makes it easier to group as many as possible, right? Volunteers, on-site visitors, vendors, right? So that way at least there's, one template. But a lot of it will have the same language. But you may also have different risks from, vendors who are coming in and they're bringing tools and things like that. But it's especially right if, we talk about volunteers too, if they're going to be interacting with program participants, right? Things like that. But the waiver is also an opportunity where you can get a photo release from the volunteer. But I'm I caution against blanket releases of, hey, for your picture. I think if you're at an event or things like that, but just having them sign and say anytime we could possibly use. Because I don't know about y'all, but I've seen some pictures taken of me that I do not want up on the interwebs. So I think, to keep that good relationship with volunteers, um, if it's going to be maybe something that's going to be a longer campaign, getting their permission is always a good thing. But that language related to release of photos can absolutely go in a waiver.
Excellent.
Yeah. And this one is a good segue to another question where somebody said, we plant trees along the streets in the city right of way. Should we have a memorandum of understanding or a contract with the city? Yes. Similar to the waiver, right? If there's a situation, it's a relationship. It is a fact of life. Relationships can go wrong and there will be problems. Nobody gets into this. Nobody's saying, hey, I'm going to volunteer and expecting something to go wrong. I'm going to go plant these trees at the city. Something's going to go wrong. But it's a fact of life. So what that contract, what that MOU does for you is it protects you if and when that thing goes wrong. And so what that MOU specifically is going to say is going to be based on what are those risks. So, right, if we're planting trees along there, who's doing it? Is it going to be your people? Who's going to be liable if they mess up something about the sidewalk, right? And let's say a biker is now coming and they run into the tree, right? Who's responsible? So especially in that, because with the city has a lot of liability when it comes to sidewalks and things like that. You want to make sure you're protected and you're not going to be assuming any of that. But that goes for any situation. Anytime I see a lot of nonprofits partnering together, and I love it, right? We are stronger when we're together, but there's never really anything in writing. and then a bill comes or there's a disagreement and now they don't know what to do because there's nothing there. What an MOU, what a contract is going to do is it's going to give you, that order of operations. What do we do when something goes wrong? It's going to spell that out and tell you. So it's really important to have things in writing when you're getting into any kind of relationship, whether with a municipality, another organization, any sort of vendor. You always want to have written contracts.
So many nonprofits are going to say, well, who has the time to get a contract written for every situation? And sometimes we're just on the fly. We're working with people. We're trying to build trust. 90% of the time, it's all fine. Who has the time for all that? Are there any guidelines you can give for folks who are sort of operating on the fly, for example, or guidance, not advice? For example, one thing I've heard is that if you can't get an employment contract as an executive director protecting you from being fired without cause, you could have a dialogue. Like when you're being given the job interview, you could have, in all 50 states, I've heard this is true. If, let's say, you, Ellie, are offering me a job as executive director, and I say to you, I want a contract, and you say, we're not going to give you a contract. And then I say, but I just don't want to be fired without cause. And you say, we would never fire you without cause. And now I've got you agreeing on camera to this. Allegedly, in most states, that is an agreement that I'm protected for cause. So is there a way to get people to just get things in writing, get them replied to, confirmed, or like, is there any general guidelines if they can't do contracts all the time?
Yeah, well, so here's the beauty is a contract does not have to be, right? We think of it as this formal thing, but it doesn't always. And so when I'm working with an organization, and most times if we're going to do a contract for an executive director, it's going to look more like a letter. It's going to look more like an offer letter because we want it to be more casual, but spelling out those things. So I would do a few things. You can ask, instead of asking for a contract, asking for it memorialized in an offer letter if they haven't already given you that, or asking for certain things to just be added to that offer letter. Because that can also seem kind of less intimidating to the board then, because if someone comes back and is like, I want a contract. What I need most people to remember about boards is most of them do not have experience dealing with HR stuff. So they might hear that, and from personal experience, they get up in arms. We're already giving this. Why do they want more? Right? So why not instead, hey, can we add this to the offer letter? I think that goes a long way. But the other thing, like I said, a contract does not have to be a formal piece. It could be sending an email and saying, can you please confirm back, right? These points that we talked about, please confirm. Now you have in writing that. So, right, it doesn't need to be this formal thing. The other thing I want to make sure people know is to be clear that just because you have a contract, it doesn't mean that you can only be terminated for cause. You can have a contract that still makes you an at-will employee. So just making sure that whatever contract or whatever documentation you're given, you're reading through it and making sure you understand that. And if you don't sign something you don't understand. Asking questions, because you have the ability and the right to do that. And I think if someone's not going to be forthcoming, that kind of gives you a hint. But make sure you understand what you're signing because, right, it doesn't always have, it can say you're still an at-will employee. It may change certain things. So you want to make sure you understand that and you're not just signing thinking it's what our conversation was. Make sure that's what's actually written.
And sometimes it's better to not have something in writing than have some assumptions about what we all agreed to. Because the minute you sign something agreeing to things, you're sort of cementing that you're giving some rights away sometimes.
Right. And that's the other thing too is for both the employee and the nonprofit, you don't want everything to be completely spelled out. And so even in an employment contract, you'll see kind of some more vague language like reasonable efforts because we don't know everything that's going to happen. But yeah, so not everything you want. And I did see that someone looks like asked what goes in. Because you did ask me, what are some pointers and that, so I want to talk about what can go in. So just to give you some guidance on kind of what things is this goes for any contract. You want to make sure first the contract says what happens if something goes wrong, right? Making sure you're protected. That is one of the most important things because without that, the contract is it's literally just a piece of paper. If it doesn't give you any ability, right, if the organization does something wrong, to take them to court or things like that. If it has an arbitration agreement, personally not a fan, they're not great, so that's another thing. But the other thing is making sure they're spelling out things like your pay, your benefits. Like the contract needs to be clear. That's really important, is making sure those things. And then the other thing, making sure is in there, is your employment at will or can you only be terminated for cause? Those are some of the big things that I would make sure are in there. Otherwise, it's really based on the situation that you're building, right? Based on their position. Confidentiality is always important, right? What are the confidentiality requirements? And then also, finally, intellectual property. If you're in a role where you're creating stuff, right, making sure it's in there and understanding that the organization who owns what you own, if there is anything you're bringing in. So depending on what you're doing, that's something that you want to take a look at.
Yeah, I definitely think that one of the other clauses, I put a link in there to a blog post I wrote about this because I do sell employment contracts for EDs, and Melinda here was able to get a contract with my sample contract. One of the things you want to include, if you can, is severance, and of course, you want to include a mutual non-disparagement. So when the two parties break off, they don't say bad things about each other. Nonprofits and our leaders tend to be in very close-knit communities, and we don't want anyone damaging the relationship with the donors and also damaging the future career of that worker. So a lot of places will have a mutual non-disparagement in the clause in the contract. Also, a lot of this stuff is in the one I sell and in the blog post I put there, which is free. So
Well, that's perfect intro because one of our questions, one of my answers. So I'll say this question and then I'll tie it in. But we had someone submit that our executive director was fired last summer for unethical behavior and has since spread negativity and lies about the ministry and its employees. What should our next steps be? Can we send a cease and desist letter from our lawyer? So I wanted to first talk about, before we get to what to do now, what can we do to hopefully in the future avoid this? And that is, people think, right, separation payments um, only come if the person didn't do anything wrong. So even if somebody was terminated for unethical behavior, I always recommend that the organization sit down as a board or whoever, whatever executive committee, and say, what is our risk of this person going out into the community and doing something like that? Because I have at least one case a month like this. And we have some very small, I live on the shoreline of Connecticut, which is very small communities. So what happens is similar to that when somebody is terminated from a nonprofit, it becomes the news of the town and it becomes he said, she said. So before, if we know that's coming, we have that conversation where I'll talk about to them, look, I know that this person did something wrong, but it may be in your best interest to still offer them some negligible sort of separation payment to make sure you have that in writing, the non-disparagement. Now, what happens if we don't? It doesn't mean you can't do anything. It just makes it a little harder because if you had that in writing, when you're sending the cease and desist, you're simply referring to that. You're saying we have these rights. So it just makes it easier. Now, what can you do? Sending a cease and desist is the next step. But I'm going to be honest, from personal experience, it doesn't really do anything. And here's why. Because there's no money at risk for them. What is the organization going to do? Unfortunately, right, you have to think if that person, they probably don't have, like, if we bring a lawsuit and we win, what do we get? No, we spent attorney's fees. And that's why I think it's really important trying to do it at the outset because call that out in there. Be like, hey, just want to make sure you see this non-defamation. Just understand. Doesn't mean you can't say anything that's true, but we want to keep a great relationship. We'll do the same and calling it out. It unfortunately is one of those situations, and we see it a lot, but it's hard once it's out there. It's really hard to get because while right, they can be wrong and saying lies, there's not it's going to cost you more to fix the problem than it's worth sometimes.
we can move on to the next.
Okay, let me. Okay. All right, we got a few that were on this thread. If a nonprofit loses their nonprofit status due to not filing for 3 years, can you still get the status reinstated retroactively with just the 1023 form, or do you always have to file the 990s first, then the 1023? So the IRS will automatically revoke your tax exemption if you have not filed your 990 or 990N in 3 years. That's on the IRS side. And so you will have to file your 990s. They're not going to reinstate it. There's a few different ways that they do it, depending on certain funding levels, I believe. But either way, you're going to have to file those 990s. The other thing you're going to have to do is the question is when you have your nonprofit, we have, right, how the federal government's involved, and the IRS says you're tax exempt, but it's your state that says you're a nonprofit, you're a non-stock corporation. So if you haven't filed your 990s, the question is, have you also not filed your state documents, right? Because even if you get the IRS reinstated, you still got to make sure your actual company, the actual corporation, and that's at the state level. So states also do a similar automatic dissolution. It varies by state, but if you haven't filed your annual report or anything that you're supposed to file, they can do that. So you also have to look at what they require. I think, Sean, you said you've done
Yeah, I had a nonprofit, scrappy little startup, one person kind of running the place, forgot to do his 990 after 3 years, thought he had someone doing it, didn't do it, got revoked, and I had to go back. Luckily, they had very little money going in or out over 3 years, so filing the paperwork to show we were able to do something very small, like the easy or whatever it was at the time. But yes, it's a pain in the butt. There's no way around it. You have to go file those three unless maybe you're a house of worship or a faith community or something like that. You generally have to go back and do that. Yeah.
Yeah, like I said, there's some small and very specific based on which ones exactly, and but it is one of those. That's the fun of the IRS, all the paperwork they make us do. Um, but let's see. So I think yeah, just to make sure I answered because I know there was a second one on that, but I think that was. So I'm going to move on. Talk about this is a great one. Someone asked, can you talk a little bit about donor privacy and the laws around this? What about when doing donor prospect research? What are the legal requirements related to donor privacy, including among the board of directors? There are no rules. And I don't, it is, so privacy law in the United States is what we call a patchwork. Basically, the internet was invented and we realized we didn't have laws to protect people against this. So what that's meant for the last several years is we keep trying, but the internet and technology keeps evolving and our laws have not caught up. The other piece is that it's mostly at the state level. So I could be here in Connecticut and I could have different requirements than somebody in Texas and somebody in Vermont. So the first thing to do is to check with your specific state and see if they have anything. Most likely, they probably don't. The other piece then is looking at just the specific funding sources you have. I've had grants before that do place limitations on just, things like that. But this is a question I get a lot, and the answer is there really isn't much legislation on it. So it's kind of comes down to that legal versus ethical. So it is one of those things. And so you have to ask, like, do we feel ethical doing this and reaching out to prospects that way? It's not one where the law is going to tell you can't.
Yeah, and I think the most important thing, or I think the heart of this question is probably, is it okay that I'm looking at this database or going out online and doing Google alerts on this donor and then contacting them and getting this information? Yes, in general it is. Now, almost all legal questions come down to a matter of risk. Higher risky behavior creates more legal risk. So you want to do as little, just ask yourself, just common sense. Am I going to take this prospect list I've built of donors and put it on the internet? Am I going to sell it? Am I going to like share it with my competitors or anyone who wants to buy it? That probably is riskier. You probably want to keep this stuff under lock and key. You want to control how many donors have access to it. But in general, if you're prospecting on donors and you come across their personal contact information, you don't want to be sharing that with the world. You want to demonstrate with internal policies that you respect people's privacy and stuff. So you can limit your risk. But I think that your overall question about can you use all this data that you're rounding up on people, probably.
Right. Yeah, that's different states are taking different measures. A lot of the privacy laws we're seeing right now relate to AI. So I don't think we're going to be seeing anything that's going to touch on this unless it's, obviously don't go putting donor information into AI. Don't, things like that. And I think that's a huge part is also like what you do with it too, right? It's you have it, but a lot of the privacy comes in like you've got it the right way, but making sure you're keeping it private. Nobody who doesn't need to know, right, outside, whether it's the advancement team or whoever is responsible for that campaign, it doesn't need to go out of there, right? And that's the same with when we talk about any sort of confidential information. One of the other biggest risks I see for a lot of organizations is when confidential information gets into the wrong hands. Either an email gets out to the wrong person, or even just someone within the organization who didn't need to know. And so just making sure your policies related to things like who needs to know what, including donor information, that's a huge risk move, and just making sure you're doing that. And there was another one related to privacy. So I want to find, it was related to the board members. So let me just say. Here it was. Is it appropriate, advisable, or necessary for a nonprofit organization to inquire about a prospective board member's criminal background, for example, convictions or felonies, particularly given, and then this organization serves vulnerable populations? So again, this is going to depend on your state, but most states you're not going to find have anything saying no. You know, you're going to find for employment. But actually, it's perfectly one of those things, right? It's okay. And actually, you should be doing it. In Connecticut, actually, we're required to do it when we start and we apply for a charity registration in order to solicit. You have to attest that none of your board members have certain charges and things like that. So we have to ask. Um, I've had organizations, right? They had independent school. Every board member is going to pass a certain background check. And so what that background check looks like will obviously depend on maybe who you're serving and whether or not the board members are going to have direct interaction. But you can absolutely. What I will say is do not do it yourself. That's a big area of risk, right? Because when we talk about background checks, we get into credit reporting, we get into discrimination issues. So you shouldn't, even though nowadays we have so much at our fingertips and we can search and things like that, you should not be doing that. It's relatively inexpensive, I would say, to get, and you can even, some organizations might ask the board member to cover that. But absolutely can, and in many cases you should, right? Think about somebody who's your treasurer. You want to make sure they don't have any issues. They're handling your money, they're doing things like that. But it's one of those things that's not just permitted, but it's advisable to use your language, and something that I've worked with a lot of organizations on. And then just to follow up on that, the other piece, and actually I see Sean putting it in consent, right? You got to always have consent to run the background check, including what that is on, right? Like if you're running on the sex offender, need to make sure doing that. The other piece is look at any grants or funding you have because they may specifically require board members to have certain kind of clearance and background checks. I've seen that as well before.
I have a client who's an international youth serving organization, and a person who made it onto the board, was there for years, was an excellent board member. Was someone reached out to the nonprofit, said years ago this person was accused of a thing at their school. Nothing turned out. They left. There was no charges, nothing criminal, but it was like there were allegations. It was enough to get this nonprofit to approach the board member. Board member said, yes, these allegations did happen. It was not true. The nonprofit asked, there was just, they needed their board members to be pristine. They need to be unimpeachable on serving youth, right? So they had someone report this. So those kinds of questions, asking people as they're joining the board, if we were to poke around, are we going to find anything at all that would bring ill repute to our organization or our reputation? If so, you need to surface that now.
Exactly. And that's why like the board application process, which shouldn't just be right an application, it should be conversations like that. So you can find that because it may be something, but it may be something that based on your organization, yes, you needed to know, but they can still serve right on your board, but you needed to know. So it's just a super important thing that not just with employees, but board members, and even depending on what your volunteers are doing, right? Volunteers might need to be getting background checks. So the next question that I wanted to talk about is about fiscal sponsorships. And this is a great one because I'm seeing them a lot more. They're just, for whatever reason, they seem to be more common. So let me just pull up this question. So the question was, how does a newly established nonprofit negotiate a fiscal sponsorship relationship? Is a fiscal sponsorship a permanent solution? So a fiscal sponsorship is an appropriate thing when your organization doesn't have tax exempt. Either you're applying for it, you're trying to see, is this a good idea? Fiscal sponsorship is not something to get into lightly because the organization that is serving as the sponsor is essentially taking all of the risk for what you're doing. They're putting it on their books. So with that said, I think when it comes to negotiating a fiscal sponsorship relationship, the first place to always start is somebody you know, right? Because similar, right? They're going to vet you. So having that warm relationship, but the most important thing, similar to what I said before, is that written fiscal sponsorship agreement. Because unfortunately, like I said, because fiscal sponsors, the sponsor is taking on a lot of that, I've seen just when there are issues because of that, it can create. And so having that roadmap where everything is written, who's responsible for what, right? Is the sponsor going to be doing your admin stuff? Are you going to be paying them a fee? Making sure everything can all be spelled out. And so, sorry. So now for the second part of the question. So can it be a permanent solution? It absolutely can. Um, it really just depends on what you're doing. So if it's kind of like seen as a project within somebody else's, that's absolutely fine. Again, it's really just if that's the agreement that you guys come up with, that's what's the most important and making sure everything is spelled out. I just had an organization that was underneath a fiscal sponsor for 30 years, and then they just apply for tax exemption, right? So again, it's where your mission is, and also because fiscal sponsorship can help access to funding, right? So it may be that piece. So it really depends on what you're doing. There may be reason to step outside of that. There may be not. We see it all sorts of ways. But what I will say from my work, the most common I see is an organization that or an idea that's just starting out. We want to see, is this going to have, is this going to have staying power before we go and put all this investment into filing the 1023 and doing that. We want to do this. And so I work with a lot of organizations on that, and fiscal sponsorship is great, but it does come with a lot of risks. So it's important to make sure that it's in writing and clear from the get-go.
Can you tackle Melinda's question, which I just put in line 30 in our
Yep.
spreadsheet?
Okay.
She's in the chat, and I asked her a complaint about what?
Okay. Yes, because I guess the question is if it's a complaint from an outside party, I would personally say no. But it really depends what you're doing. You should always have internal complaint mechanisms for employees. That doesn't need to be on the website or anything. Without anything more, I can't think of a situation where someone would need to file a complaint internally for something that I came across on the website. So I don't know if she has an example. Partner complaint donor. So, okay. Yeah. Yeah. I wouldn't, because you don't want that information out to other people. They should have, whoever their contact is, but also in whatever agreement you have, right, with that partner for that one example, the complaint mechanism is in the contract. I'm trying to pull up to see what the other examples.
Yeah, and Melinda, I think that if you're serving many thousands of people, like a lot of companies and nonprofits, they may have a give us your feedback. Like there may be like a feedback mechanism on the site. I wouldn't open it up to be like, do you want to issue complaints about us? You are creating more risk for your organization than not. But if you have a little feedback spot on the site, and then there could be a form that they're filling out to see whether this is like, hey, one of your employees was rude to me at the Susan G. Komen, breast cancer walk, or what are they complaining about? So in general, you'd want this to be a very private thing. But a feedback mechanism might be true, which is just an email form, right? But I wouldn't be opening it up like, hey, if you got complaints about us, tell us about your complaints.
The only situation I could see is if you run anything sort of healthcare related and you have to have like the HIPAA, a privacy officer. So if you do anything like that, but otherwise, yeah, I think that kind of feedback form is sufficient. So this is an interesting one. We are a 20-year 501c3 nonprofit organization. How have laws changed to ensure we are in IRS compliance in 2026 and moving forward? They really haven't changed. And that's the thing, right? Like I said, the law has stayed pretty static. It's more so, and our technology is changing, and they're slow to do that. What has changed, what is the enforcement of it, right? Because we have all this new technology, it's a lot easier for them to enforce. And what I mean by that is I've worked with a lot of older organizations who everything was on paper, in boxes, and things like that. So when it came time to need to submit certain things for audits, they were flagged for an audit because we couldn't quickly pull things. And so that raised more questions. And so I think the biggest thing that's changed is just how to comply, right? And so if you are an older organization, it's a worthwhile investment in making sure your documents are digitized, right? Whether that be old board minutes, um, things like that, any resolutions, making sure there's a central repository for all your board documents. I see that a lot that there's, and it can be a Google Drive, right? Just making sure there's a central place. So like I said, it's less about the laws have really changed. It's more so just that they're kind of enforcing more because they do have the ability, right? We can see more with the technology. They have access to more. So what that also means is things like, right, your organization is more forward facing. So making sure whatever is on your website is ADA compliant and doesn't, call out anything of issue and just things like that. Um, and as far as just making sure staying in compliance, it's really making sure your board goes through, their fiduciary duties and that they're not just signing off on things, that they're actually taking the time, looking through decisions, because at the end of the day, the IRS recognizes that the people running nonprofits are human. And if your actions, for the most part, are reasonable, taken in good faith, it's not going to be an issue. But if they see that you've just completely said, washed your hands of it and are not really paying attention, board members have a requirement to be active, to be present, to participate. And so I think that's really making sure that's really important to do to stay in compliance with the IRS and anything that they may do down the road.
Can you handle, Tanisha's here on the call, she's a client also. Can you
Yeah.
handle, she's in question line 13,
Yeah.
I submitted yesterday.
Okay. But 13, hold on. Okay. All right. Sorry. I meant to do that when we were talking about the executive director. My former treasurer will not relinquish admin role on our sam.gov account. I'm being advised by fsd.gov to take legal actions. They can't remove the individual without a court order. I tried everything and now about to hire an attorney. Is this my only option? Unfortunately, if that's what they're telling you, because they have their own sort of systems and rules, and as somebody who has tried to get access to for example, SBA accounts for my clients or things like that. I've seen similar where if we don't have the original person's information, they will not give it. So unfortunately, if that's what they're telling you, it likely will be. But it's possible it may not need a court order. I would speak with an attorney and I would also ask them, is it sufficient if we had just a correspondence from an attorney instead of a court order? I'd go back to them and ask at least that because that will at least be a lot cheaper than having to take something to court versus just getting an attorney to write something.
This is a good lesson that when people leave our nonprofits, they sometimes take their email accounts with them, they take passwords with them, they take IP with them. It's very important, even with your all scrappy volunteer board, to make sure that no one can be setting up accounts and that they can leave and own access to those accounts. There should be an official sort of email that's attached for the organization to use. Like anything that belongs to the organization should all be used with a Gmail account or a Google Workspace account or something that anyone on the board can get access to. You don't want someone like this who runs off and now is holding the organization hostage in a way. If they're no longer with the organization, they cannot represent themselves to sam.gov as being with your organization. So if they're just not relinquishing the password, then you can just like set up a new account on SAM and argue with FSD about whether or not you can just combine the two accounts, right? While you're doing a legal parallel track. But because there's information inside sam.gov, you can just go tell them that this is actually you and that person had left, but trying to track down that password and that login might be a lost cause.
Something that I always try to do is make sure that at least two people have each piece of information, right? Because it's also whether somebody leaves. Unfortunately, I've had people pass away, right? Like it is, and especially on as if it's a board member, treasurer, and it's a volunteer role, more likely to go missing in action or have family emergency. So making sure there's always someone else who can access things is super important.
You may also want to contact the Attorney General in your state, Tanisha, in New Jersey, to see whether or not there's anything they can do. The last thing they want is a letter from the Attorney General's office saying that they're in possession of private property that belongs to the nonprofit. It could just be something the state offers. I don't think so, but it could be the kind of letter no one wants to get.
And I think that's just a great point in general that the attorney generals in your states they're the ones who are responsible for overseeing nonprofits, and they can be a great resource. Wasn't the same situation, but we had a past employee who took all the money. And the attorney general has stepped in to assist because issues and the person just, you know, um, so just to say, use your attorney general as resources, and every state is different. But personally, I've had great success finding them helpful. So that is a great resource when you find yourself in a bind. Looks like we got another
Yeah.
question in. Um,
That's from Melinda also. She just wants to know whether they qualify as a fiscal sponsor. I was gonna tackle that in the chat, but if you can answer it live, that'd be great.
Yeah, so it looks like we are unique in that we provide fiscal intermediary service for international orgs. And so wanted to know if she'd be considered a fiscal sponsor or what we classified as. So if they're not US based, if they're international, and that's not the same as a fiscal sponsor, it's essentially a fiscal intermediary, like you called it. To be a fiscal sponsor, it would have to be an organization based here that doesn't have their own 501(c)(3), and the fiscal sponsor isn't necessarily even providing anything. They're just giving them a house to live in, right? To underneath their organization. So these guys are not part of your organization, like it would be in a fiscal sponsor. So that would be a different scenario.
But if Melinda's organization is based in the US and they help organizations overseas who are not incorporated in the US, they help the donors in the US get a tax exempt letter for their donations to these overseas organizations. If the fiscal sponsor, if the organization's like, oh yes, I'll take this money from the donor and then give a thank you letter back to the donor and then move the money overseas, that's technically a form of fiscal sponsorship, wouldn't it? And they're absorbing a lot of risk
Well,
to
that's, I guess it really depends how much, like what yeah, is the international org, are they established in their country as a separate and they have their own, or are they just a project? But I think too, the term fiscal sponsor, it really is just a term. It's a term of art in a sense. So whether or not it fits, it's not an issue. But either way, what's important is making sure that what agreements you have with those international organizations is ironclad, especially when we're talking about crossing, country boundaries. Things get even riskier. So just making sure what's in writing reflects the relationship and protects you guys.
We have 6 minutes left. Let's see if we can tackle two
Okay,
more
let's
questions.
see. So we got one. I won't read the whole thing, but somebody was asking, they're an ED for a small nonprofit, but they're also involved in a PTA, and whether or not they should seek, it's necessary to have an attorney to help with the 1023 EZ application. And so that's the first part of the question. I will say this. So the 1023 EZ, much simpler, I think 2 pages currently. What I always tell people before I even work with a brand new nonprofit that I'm going to form, especially if they're going to do the 1023 easy, I say take a look at the forms yourself. Because everybody that's forming a nonprofit or whatever, they're coming from different backgrounds and have, different information. Look at that first and then see, do you think you can do this yourself? Do you only need me to kind of answer some questions, which is usually what it is? So all that to say, it can be done on your own. I highly recommend, though, at least having a lawyer review because, right, this is where you're saying this is our mission. And now everything, when you're filing the 990 and anything that they're looking to make sure you're meeting your exempt purpose, all your activities is going to come back to that application, right? That's your holy grail. It's kind of like your constitution. So I think it's always wise just to take, some extra time to ask, a lawyer to review that. With the caveat that not every lawyer understands nonprofit. So it's making sure you're working with a lawyer that understands nonprofit. Now, the great thing about the 1023 EZ too is I just got one in like 3 weeks. So they're still, going pretty quickly. If it's the 1023, that does have a lot more, and you're talking about things with financial. That one, I would say absolutely, I recommend working with a lawyer. But
And
and
the
the other piece,
1023 easy is mostly for groups that are plan on bringing in less than 50K a year in revenue.
50K for each of the first 3 years. Yep. And that's revenue from all sources, whether it be grants, individual donors. And a lot of people say to me, I don't know how. And the IRS does understand that. If you were to go over that, they're going to ask, well, did you have a reasonable belief that, like, was it reasonable to believe you were going to be under that? So my client, he was like, well, what if somebody like all of a sudden they die and they donate their house for us to use? Like, yes, we couldn't have foreseen that, right? The IRS is not going to penalize you for that. But if you're not sure, I always say file the 1023. It is a little more money. It can take, much longer. You can file for faster service, expedited. But yeah. So the other piece of this question was if there was any downside to their outgoing or current PTA executive board initiating incorporation and a Form 1023 EZ. I don't think so. Again, as long as you have it written down somewhere in your board minutes that this is what, right, we voted, we have approved, we're going to be doing this. This is which position is going to be responsible for that. Then there's no harm, right? Boards and nonprofits, right? We are constantly changing people, so it's very common. But also, like I said, the 1023 easy, you can get approval in 3 weeks. So if you're going that route, that may not even be an issue of having to wait between terms.
We have 3 minutes left. We're going to do a pretty hard stop at 3 o'clock Eastern. So
Okay.
if you think you can tackle one more.
Um, Well, I don't know if I can talk like these, but I want to, if I can mention something that I've been getting a lot of questions about and what I do, and that's paying volunteers. Whether or not you can pay volunteers and not necessarily like, hey, I'm going to pay you for hour, but any sort of benefits, gift cards and things. And I will say that comes down to state law. The example being here in Connecticut, you can, but if you do, then you'll be liable if they get hurt, right? You lose that volunteer liability protection. Normally, if they got hurt while they were volunteering for me, it's not my issue. If I pay them, I do. So with that time we have, just it is possible to give benefits, some sorts of payments to volunteers, but there are rules around that. And then as far as how you can find me, so Levene Legal, Levene, I'll put it in the chat, legal.com. And I'll put my email addresses there as well. Very happy if you have any follow-up questions from what I talked about, or if you submitted a question and we didn't get to it, more than happy. I'm going to put that in the chat right now if my chat wants to cooperate.
This video will live on as a replay. It'll also go up on my YouTube channel, and you can always reach out to Allie with her website, which she just put in the chat. If you liked today's conversation, give us a plus sign in the chat. If you enjoyed having this access to free legal questions to be answered, give us a plus sign in the chat. If you'd like to give a testimonial to Allie or to me with 1 or 2 sentences in the chat, we always love those also. Testimonials help us do better and help us get to share the good word. So Allie does amazing work. She's my first call when I have questions about stuff like this. And if any of you need access to legal services, please consider her. Thanks for tuning in today. And again, reach out to her with her website, which she put in the chat. You'll all get a post-webinar email about the way to access the replay also. And thank you all for being here today. I'm going to linger for another minute. And Allie, if you can hang on for another
Yeah,
until 3 o'clock.
absolutely.
And if anyone wants to submit a testimonial in the chat, a 1 or 2 sentence thing, that would be great. This is fun. I love tackling these things. I love when what I believed was right.
Yeah, no, but I just love the conversation and how it sparks people's minds, and it's great.
Yeah. Excellent. All right. So if no other questions come in, then I will just say for the recording, if you're, as Allie mentioned, if your questions were not tackled, please feel free to reach out to her for those and just mention that you were on this part of this and registered for this conversation today. Thank you, Allie, for being with us today. I hope to be in touch with you very soon.
All right, bye guys.
Thank you.